that petitioner number 2 had never harassed the de facto complainant in any manner. And further, that the petitioner number 2 is a senior citizen and is facing difficulties
Your Honor,
in attending the proceedings. He therefore he further pointed out that the de facto complainant herself has alleged that one talaq is pronounced,
may I please,
and
Your Honor?
in another instance it is written as triple talaq in the charge sheet. Thus, it is totally false and concocted. Set of allegations are levelled against the petitioners. He therefore prayed to quash the same. The learned PP has submitted that the charge sheet points out the allegations levelled against the petitioners under so and so offences, and that doctor is also listed as LW3, who issued medical certificate with regard to the injuries sustained by LW.
Your Honor, may I please?
He therefore prayed to dismiss the petition. Produce the record. The record discloses yes.
May I please? Your Honor, Article 142 of the Constitution may be into consideration.
142. This court does not have power.
Okay. Sorry, I will. Okay. Another thing, Your Honor, if possible, this court, because it's my, I'm learning Article 311 of the Constitution of, because the authorities here in this case, so maybe consider that in this subject matter, the provisions what they attracted, what the investigation they did.
Article 311.
311. If it is maybe, please consider. Because
the record discloses the allegations against the petitions under so and so, and the CC number 3916 of 25 is pending on file of ACM, 15th ACM Hyderabad. The veracity of the witnesses and the truth or otherwise in the allegations is a subject matter of trial. Hence, the petition is disposed of, dispensing with the attendance of the petitioners before the trial court, provided that they are represented by a counsel on every date of hearing, and unless they are, whenever they are specifically required that the trial court they should be present. Yes.
I
Next.
deeply obliged.
This is a quash petition filed
Yes.
against the untenable FIR filed by the police under section 74, 79, 351, 1152 ANS, Your Lordship.
Yes.
Your Lordship, I have invited the attention of this Honorable Court to the complaint lodged by the de facto complaint, page number 12. Your Lordship. I may be
Yes.
permitted to read out the complaint, Your Lordship.
Yes.
Harassment, blackmail, death, physical violence. I am Sampada Rameshetty, daughter of Ramesh Babu. Rameshetty, age 24 years, occupation working as technical support, residence of so and so. I, Sampada, residing at Sri Shankar Colony, road number 3, I am writing to formally lodge a complaint against Peddi Bhanu Uttej, who has been harassing me for the past 3 days. I was been in relationship with him, which has completely ended from our end. My family knows about this incident. It has been almost a year where we are not in contact, and all of a sudden he and his current girlfriend started contacting me, and his current girlfriend, she is calling me to know what exactly happened between me and Bhanu in past, and I clearly informed both of them not to contact me anymore, or else I will be raising complaint on both of them as they are harassing me. They started abusing me on call. Bhanu and his girlfriend started giving me death threats as I did not respond to them properly. On the date of 5/8/2025, where I decided to give complaint on them, and I reached Libnagar police station on 5/8/2025 around 1 p.m. He sent a text message along with a picture where it showing that he is in front of my home to my cousin. When I was in Elbinagar police station, I got a call from my mother, stated that Bhanu came into our home and started physical violence. This is the only criminal ingredient containing in this complaint, which even did not clearly disclose what kind of physical violence allegedly committed by the petitioner. So now I fear for my life and my family safety, and I request you to take immediate legal action against Bhanu Uttej and Vaishnavi under relevant sections of the IPC and IT Act. I also request to ensure our protection. This is the complaint. Your Lordship is well aware in the light of judgment of Honorable Constitution Bench of Supreme Court of India in Lalita Kumari case. when the complaint ingredients discloses the cognizance of the FIR should be registered. But in this case, the police showing extra enthusiasm for the reasons best known to them, applied section 354 IPC even without any iota of whisper by the de facto complainant in her complaint. Your Lordship may kindly come to page number 13, Your Lordship. In addition to registration this FIR, misusing their official position, the police glaringly violated the circular issued by Honorable High Court for the state of Telangana via ROC number 1399 SO 2023 dated 9/8/2023, Your Lordship. This is the circular issued by the Honorable High Court of Telangana to various judicial magistrates of this state as well as to the Director General of Police Telangana in the light of law laid down by Honorable Supreme Court of India in criminal appeal number 2207 of 23 in special law petition SLP criminal number 3433 of 23 between MT Ashwa Kalam versus the state of Jharkhand and other. Well, Lordship may kindly come to page number 14. The relevant paragraph is 11.5 point. The decision not to arrest an accused be forwarded to the magistrate within 2 weeks from the date of the institution of the case with a copy to the magistrate which may extend by the superintendent of police of the district for the reasons to be recorded in writing. Notice of appearance in terms of section 41 CRPC be served on the accused within 2 weeks from the date of institution of the case, which may be extended by the superintendent of police of the district for the reasons to be recorded in writing. Authorizing detention without regarding this is the point number 12 is we hasten to add that the directions aforesaid shall not only apply to the case under section 498 IPC or section 4 of the dowry.
Yes.
So this circular is also glaringly violated by the police officer in this case. Now kindly come to page number 36 of the Honorable Supreme Court of India judgment, wherein the Honorable Supreme Court of India laid down the law with regard to applicability of section 354 IPC. Your Lordship be kindly permitted to read out para number 14. Further, the provision in Article 15 prescribed discrimination by the state in all its forms on various grounds, including gender. Article 15 enables the state to enact special provisions for women and children. Turning to the facts of the instant case, keeping in view the contents of the FIR, the statement in final report of the investigation officer, and the statement under section 164 CRPC of the complaint, we are of the view that even prima facie the ingredient as referred to supra are not met. The record is silent with respect to the use of any force. To apply section 354 IPC, there must be an ingredient element of using criminal force, which is also not there in this complaint, Your Lordship. My humble submission, before ordering the PP to get instructions, I request this Honorable Court, in view of the circular of the Honorable High Court of Telangana, may be followed by the respondents meantime.
Sir.
Last may kindly see the statement recorded by the prosecution and also certificate notice. I'm sorry, Lord, I have only one copy, Lord. The last 5-6 lines is relevant, Lord. Bottom, Lord.
My humble submission to Your Lordship is 161 statement shall not be used for any other purpose except to contradict the witness during the course of cross-examination as per section 45 of Indian Evidence Act, as well as the law laid down by Honorable Constitution Bench of Honorable Supreme Court of India in Tahsildar Singh case versus State of UP. The prosecution cannot rely on 161 statement before this Honorable Court, saying that have some sanctity and credibility. Everything should be in complaint only. That is the observation of Supreme Court.
35 notice, Lord. Next page is 35 notice. The flag, the last page.
Yes, yes. Did they take it and reply to that?
They responded, Lord.
They can create a notice as if issued in ante-date also, Your Lordship. That they have to maintain a register, Your Lordship, with regard to the issuance of 41 CRPC notice. The acknowledgement register should also be produced before the court.
Counsel for orders 12/9.
Oblige.
Lord, so this is a